Welcome to today's webinar, Marijuana Still Dangerous, Still Illegal in the Workplace, presented by Employment Background Investigations and OraSure Technologies. Today's subject matter seems to get more confusing by the day. In some states, medical marijuana is legal. In others, people are free to smoke whenever they want. Some states are lowering the punishments for possession, while others are holding their ground, refusing to make anything legal when it comes to pot. To top it all off, as all of these things are happening, marijuana is still illegal as far as the federal government is concerned. How can employers navigate all of these changes? Our experts are going to help you with that today. Now let's introduce everyone. I'm Jennifer Gladstone. I'm the editor of EBI's Screening News Network. I'll be serving as your moderator today. Our first presenter is EBI's Chief Knowledge Officer, Robert Capwell, who's responsible for EBI's quality management and information security management systems in accordance with ISO standards. Bob has more than 22 years of experience in the background screening industry and is the past chairman of the board of directors for the National Association of Professional Background Screeners. He's also an author and presenter on various topics related to the screening industry. Bill Current is the president and founding partner of the Current Consulting Group and is the publisher of the online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com. He is the author of 10 books on substance abuse-related issues, including the popular title, Why Drug Testing? Bill is also the former executive director of the American Council for Drug Education and vice president of consulting for Employee Information Services. Current Consulting Group is a leading provider of drug testing policy writing services, working with companies to help them optimize their drug testing ROI. Bob is now going to start us off with an overview, and then Bill will make his presentation. Afterwards, we'll have a question and answer period, so please send us your questions through the chat feature on your screen. Now let's hand things over to Bob Capwell, EBI's Chief Knowledge Officer.
Well, thank you, Jennifer, for the warm introduction. I appreciate it. Just wanted to give the audience a little background about EBI. EBI was founded back in 1994. We are a global provider of comprehensive background screening, drug testing, occupational health screening, and electronic I-9 solutions. We serve small, mid-size, and enterprise-wide employers. And for those interested in drug testing products and services, we are a full-service third-party administrator for non-DOT and DOT drug testing programs, which include pre-employment, random, for-cause, and post-accident testing. We provide all the products and services you need with cutting-edge technology and with a keen focus on customer service. EBI is also accredited by the National Association of Professional Background Screeners. We are one of only a handful of accredited companies out of several hundred to choose from. As part of our accreditation, we are required to demonstrate proficiencies in information security, legal compliance, researcher and verification standards, and client education as they relate to industry best practices. When selecting a provider, I encourage everyone to consider an accredited firm. With today's landscape of security breaches and concerns of identity theft, EBI is also an ISO 27001 certified company for information security. We've incorporated an information security management system to reduce the risk of security incidents. And EBI is also an ISO 9001 certified company in quality management. We've incorporated a quality management system focused on timeliness, accuracy, and compliant information with a keen focus on unparalleled customer service. We would certainly enjoy talking to everyone attending today, and thank you for attending. And on to today's topic of discussion. So marijuana use is a growing problem in the United States and is taking a heavy toll on American companies. Numerous studies and reports show that employees who use marijuana and come to work under the influence have the tendency to have poor work performance, frequently call off or arrive at work late, frequently change jobs, struggle with productivity, and add to risks related to workplace safety and security. I want to remind the audience that 75% of drug users are employed. And according to the National Council of Alcoholism and Drug Dependence, Drug abuse costs employers $81 billion annually. Even in states where marijuana has been legalized, employers have the responsibility and obligation to ensure that their workplaces are safe and productive for all. This can only be achieved with a drug testing program that continues to include testing for marijuana. At EBI, we get asked the question all the time, is it legal to test for marijuana in a state where the drug has been legalized? The answer is yes, although there may be conditions that apply, and certainly Bill will go through those. There are a lot of misinformation floating around marijuana. Most are coming from people who advocate for legalization. Despite what you may have heard or read, marijuana is still dangerous and by law still illegal in the workplace and in other parts of society. I just want to remind everyone that marijuana is still listed as a Schedule I drug under the Controlled Substance Act. We appreciate the time and assistance of OraSure Technologies in providing today's webinar for you, and we appreciate your time. EBI is committed to bringing clients and readers education around today's screening trends and challenges that affect their screening programs. We thank you for joining us, and now I turn the presentation over to Bill Current, who will talk about more specifics on marijuana legislation and drug testing best practices. Thank you.
Well, thank you very much, Bob, and you're absolutely right. There is a lot of misinformation circulating throughout the country on the subject of marijuana. Is it legal? And if so, what rights do employers have? Can you still test for marijuana? If somebody tests positive, can you still hold that person accountable? Is there still the option to impose adverse employment action, et cetera, et cetera? And so we're going to get into all of those subjects today. And I'm really excited to be part of this webinar with EBI today and also with our other co-host, OraSure Technologies. Each year for the last 16 years at the Current Consulting Group, we have conducted a survey of the drug testing industry, and we ask a series of questions related to trends and future trends. And one of the things that we do as part of that survey is to ask brand name recognition questions. Which brand names in the industry come to your mind when we talk about lab-based urine testing, when we talk about point-of-collection testing? And without exception, every year that we've asked that question, and for the last 5 years that we've included it consistently from year to year, OraSure Technologies is recognized as the number one brand name in oral fluid testing. And so we're thankful to OraSure for hosting these monthly webinars and to be co-hosting and co-sponsoring today with EBI. I'm going to take us through just a little bit of information to sort of set the table so that we're all sort of coming from this at the same angle. And then we'll, as Bob said, we'll get into specifics in terms of laws, pending legislation, some issues that are on the ballot next week throughout the country as part of these midterm elections. And then we'll talk a little bit about your actual drug testing policy and how to address marijuana, even if you're in a state, or even specifically if you're in a state where marijuana has been legalized, either for recreational use, as is the case in Colorado and Washington, or for medical purposes, which is the case in 23 states plus the District of Columbia. So every year the federal government comes out with a study, that gives us a real good look at drug use trends. It's called the National Survey on Drug Use and Health. And this survey estimates the number of individuals who admit to being current illicit drug users, past year illicit drug users, or having tried illicit drugs at least once in their lifetime. We're focusing today on past month users. These are people who admit during the survey that they have used an illicit drug at least once in the 30 days just prior to participating in the survey. And so when using that number, over 24 million Americans 12 and older admit to being past month or current illicit drug users. This is over almost 9.5% of the population in the United States 12 and older. 22.4 million current illicit drug users 18 and older, about almost 69%, were employed either full or part-time. And among the adults 18 and older who were unemployed, this is a really scary part, 18.2% admit to being current illicit drug users. Now, these are people who used drugs at least once in the last 30 days. It doesn't mean they only used once in the last 30 days. And what's really, really disturbing is that the government decided to do a study on this survey to find out just how accurate these figures were. And they concluded that these numbers are about 1/3 lower than what they really should be. And so we're looking at, as Bob said, over 3/4 of adults being illicit drug users being employed full or part-time, and closer to 32 million Americans who are past month users of illicit drugs. And the vast majority of those individuals are using marijuana. Marijuana, the #1 drug of choice in the United States, and close on its heels is prescription drugs. For many, many years, as I've been tracking this issue for 25 years now, cocaine was always #2. Marijuana has always been #1, cocaine #2. But over the last 5 years, the sort of family of prescription drugs, these psychotherapeutic substances, like the hydrocodones and the oxycodones, et cetera, have moved up and have exceeded cocaine to move into the #2 position. And I only mention that because in the subject of when we're talking about drug testing, which we will today, and more specifically about testing for marijuana, if you're an employer and you truly have an interest and a desire to have a drug-free workplace program and a drug-free workplace itself, then you've got to test for the drugs that people are using. And the 2 drugs that people are using most commonly are, of course, marijuana and this family of psychotherapeutic drugs, prescription substances. And if you're not testing for those 2 drugs, then there's really no way that you can be assured or guarantee your clients or the general public that you have a drug-free workforce and a drug-free workplace, because those are the drugs that people are using. And we're going to talk about the whole issue of testing for marijuana in this sort of atmosphere in which marijuana is being legalized in one state after another. And I'm going to catch you up on the legislation that's pending for next week. But we do know that individuals under the influence of marijuana just make poor and sometimes dangerous employees. Certainly they're inconsistent in their work quality, their job performance, their attendance, things of that nature. But they also tend to be involved in a lot more accidents. They file 5 times more workers' compensation claims compared to their non-drug using coworkers. And the really sad thing is that in the workplace, your employees know who the drug users are. They know who's using drugs. They know who's at work under the influence of drugs. And I was part of a series of surveys that we did through the Gallup organization some years ago, where we asked individuals, what's your attitude about drugs in the workplace, being a non-drug user? And by overwhelming percentages, individuals who do not use drugs, 1, know who the drug users are, and 2, wish their employers would do more about drug abuse in the workplace to secure both the safety and the productivity of the workplace. And that's becoming increasingly more difficult as we live in a society where marijuana or pot is being legalized, sometimes through the vote of the public and oftentimes through legislators who maybe are even going against the popular opinion and trend of people in their state and legalizing it legislatively. But by vote of voters, November 12, 2012 will go down in history as perhaps the day the drug war went up in smoke, because that's the day Colorado and Washington voters voted to legalize marijuana, not for medical purposes, but for recreational use. And I kind of tend not to like that word recreational when it comes to using marijuana. But that's essentially the gist of it. Marijuana is legal in Colorado and in Washington. Now, in Colorado, when they passed their law back in 2012, that legislation did contain a workplace provision. I'm going to walk you through that. Washington, however, did not. So there were some things that Colorado didn't anticipate, but one of them was the impact that legal marijuana might have on the workplace. The Colorado law says nothing in this section is intended to require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growing of marijuana in the workplace, or, and this is very important, to affect the ability of employers to have policies restricting the use of marijuana by employees. This is very, very carefully crafted language here, because on the one hand, it looks like employers have the right to do something about individuals who are either using or consuming or sharing or even displaying marijuana in the workplace. But the Colorado law goes one step further. It basically says that employers have the ability to restrict the use of marijuana by employees, not necessarily just the use in the workplace. Now, this is not something that the pro-marijuana people are very crazy about. I'm going to explain a little bit about that in a second here. But let me first explain the situation in Washington. Washington also voted back in 2012 to legalize marijuana for recreational purposes, but their law contained no, and it still contains no provision for the workplace. Well, that's created a lot of confusion in Washington, because you've got employers who have drug testing programs, and there is no guidance in the Washington law. It does, to some extent, leave the interpretation up to the employer, but it also creates a lot of confusion. The federal government has sort of stepped into the breach here, okay? Now, this is a statement from the Department of Justice from October 2009, but even as early as this morning, there was a headline about the Department of Justice. This is the Federal Department of Justice, and its optimism, that was the article, the optimism that they have for the legalization of marijuana in Colorado and Washington and how well it's going. But the basic point of their message in October 2009 regarding medical marijuana is that it, quote unquote, will not be a priority to use federal resources to prosecute patients with serious illnesses or their caregivers who are complying with state laws on medical marijuana. That statement has now been extended to recreational marijuana in Washington and Colorado. In other words, the Department of Justice is saying, if a state passes a law, then how could it be our position or authority to step in and say they can't pass that law? But essentially, that's what the federal government has the authority to do. That's why I'm going to show you a court case in Colorado where the judge ruled, in fact, that the federal law trumps the state law when it comes to medical marijuana. This is a big case, and it's ongoing in the state of Colorado. The Department of Transportation has taken a completely different position, not only on medical marijuana, but also on recreational marijuana in any state that passes it, Colorado, Washington, or any of the states next week that may follow Colorado and Washington's example. Essentially, what DOT has said is that no state initiatives, no matter how legal they make marijuana, will have any bearing on the Department of Transportation's drug testing regulations. And furthermore, and they were very clear about this, medical review officers will not be authorized to verify a positive test as negative based upon learning that the individual is a registered marijuana user or a recreational marijuana user. This is very important because this goes contrary to the actual laws that exist in some of these states. And I've got all this language for you here. You can read it afterwards because we're going to make these slides available to you. But in the second paragraph underlined, it remains unacceptable for any safety-sensitive employee subject to drug testing under the DOT drug testing regulations to use marijuana, plain and simple. Yet, there is a growing number of states that are introducing legislation to legalize marijuana. On the left are the bills from 2013. On the right, in smaller type, a longer list, are the bills from 2014. And in green, you see the states that actually have medical marijuana laws already. These are the states that have medical marijuana laws already that are considering passing recreational marijuana laws. And I'm going to get into some specifics here in a moment. But this is important because it's a growing number of states that are considering legalizing marijuana for any purpose. And the battleground, the most promising territory, are these states that have already softened the ground, so to speak, by passing medical marijuana legislation. And then on this next list, these are the states, and this is kind of a moving target. These are the states that are projected to legalize marijuana next week: Alaska, Arizona, California, Oregon, plus the District of Columbia. I would say that, just in my opinion, I went on and I reviewed the Marijuana Policy Project website this morning, also the NORML website this morning, just to see what they're predicting for next week. And just going by what they're saying, we could probably expect to see marijuana legalized probably in Alaska, probably in Oregon, and definitely they are predicting in the District of Columbia. Oregon, as you may remember, fell just a few percentage points short of legalizing marijuana along with Colorado and Washington back in 2012. But these are the states that are still in play next week for legalizing marijuana generally. When we talk about medical marijuana, there's a little bit more of an appetite for it. So these are the states that have legalized marijuana for medical purposes so far. And in green are the 3 states that have passed full-blown medical marijuana laws so far in 2014: Maryland, Minnesota, and New York. And then, of course, you have the District of Columbia. Last year, you had Illinois and New Hampshire on this list as states that had just passed laws for medical marijuana. This is the list of states that had bills either before legislators or perhaps being on the ballot for next week. And so you see Maryland, Minnesota, New York, they're green because they did pass theirs. You see some very conservative red states on here that typically you wouldn't think of them looking at such a change in the law. And you notice I've got Florida half green and half black. Earlier in the year, and I live in Florida, earlier in the year, Governor Scott signed legislation that legalizes marijuana for very, very specific and a very narrow list of medical conditions. If you go onto the Marijuana Policy Project website, they don't consider this Florida to be one of the states where they've passed medical marijuana. And in fact, it doesn't include actually smoking marijuana here in Florida. There is an initiative on the ballot next week here in Florida. All of the state will be voting on it to legalize marijuana for medical purposes in the same way that it's been legalized in many other states. And so next week will really tell the tale of the future of legal marijuana in the state of Florida. And remember, it's the states that have passed medical marijuana where the pro-marijuana people are really putting their resources in terms of recreational marijuana. And so if Florida does become a state with a full-blown medical marijuana law next week, then it goes on to the list of states where they're really going to pour some resources into to try to get it legalized, generally speaking. And I've got one of my very last slides will give you a little bit of insight into that. Now, when it comes to medical marijuana, this is very, very interesting. It's a very intricate part of the legalization movement. It's to basically decriminalize use of marijuana by individuals with very serious medical conditions. Physicians may only recommend marijuana use. They may not prescribe it. Why? Because, as Bob mentioned, marijuana is still a Scheduled I controlled substance under the Controlled Substances Act. This prevents it from being prescribed by a physician. So some marijuana bills have actually died before legislatures in their respective states because whoever crafted that language used the word prescribe instead of recommend, and that gave a governor a loophole that he could use to veto a bill, or legislators, it gave them a little breathing room so they didn't have to vote on it. But that's how carefully these things are worded. You don't see that mistake being made very often anymore. In California, this is very interesting. This is not really something you see in other states quite as much. It removes state-level criminal penalties on the use, possession, and cultivation of marijuana by patients who possess a, quote, written or oral recommendation. So in California, you don't necessarily have to have a written recommendation from your doctor. An oral recommendation will do. And as you see at the bottom, all of these medical marijuana laws have something like this. It'll be a long list of very legitimate medical conditions, including things like cancer, multiple sclerosis, all kinds of different very legitimate illnesses that people suffer with. Well, you'll almost always find this catchphrase this is what you find in California, other chronic or persistent medical symptoms. So that basically leaves the door open for almost anything, right? The example I like to use is, on Friday night when I'm relaxing after a hard day and a hard week of work, my wife comes in and reminds me that I've got to take out the trash. Well, that's very stressful. So it seems like that stress ought to be, justification enough for me to smoke a joint or two out in the garage while I'm getting the trash ready, so that I can come back into the house and, be in a good mood again. In California, there's nothing preventing a physician from either writing a recommendation or giving me an oral recommendation to smoke marijuana because of that stress. Now, I don't smoke marijuana, and I try to remember to take out the trash every Friday night like I'm supposed to. But that's how ridiculous sometimes this can be, especially there have been articles and documentation of this, especially in California, where people have certainly taken advantage of this. You expect people to take advantage of this anywhere where marijuana has been legalized for medicinal purposes. But it goes to extremes in California. The thing you want to look for as an employer is if there is language in your state's medical marijuana law specifically related to the workplace. Now, I mentioned New Hampshire passed their law last year. New Hampshire has some very specific workplace language in it. Some of the states that have passed medical marijuana laws have nothing about the workplace. I'm going to show you a couple of slides here that kind of underline the direction the pro-marijuana people are willing to go. So in New Hampshire, nothing in the law shall exempt any person from arrest or prosecution. Okay, so this is not the employer doing anything, but arrest or prosecution for being under the influence of cannabis while operating a motor vehicle, commercial vehicle, boat, et cetera, or number two, being in his or her place of employment without the written permission of the employer, or three, operating heavy machinery or handling a dangerous instrumentality. Isn't that interesting, right? Because if you're an employer, you would be crazy to give your employee written permission to be at work under the influence of marijuana. That would be like saying basically, come and sue me when my employee hurts you or damages your property or messes up your tax return, because here's the written proof that I allowed them to work on your tax return or to drive my trucks or et cetera while using marijuana or while being under the influence of marijuana. Who's really going to do that, right? So it seems on the surface as if it's working in favor of the employer, but in reality, it's not. Now, New Hampshire goes a step further, okay, to their credit. Nothing in this chapter shall be construed to require any accommodation of the therapeutic use of cannabis on the property or premises of any place of employment. And it goes on to say, this chapter shall in no way limit an employer's ability to discipline an employee for ingesting cannabis in the workplace or for working while under the influence of cannabis. So it does make up for that crazy language on the preceding slide. But it really, when you read this, you think, oh, good. But this really points to your drug testing policy and underscores the importance of making sure your policy includes a marijuana section and that you're very specific. And I've got a whole section of my presentation coming up on the policy. Now, Illinois passed a law last year, and they're one of the few states, there are several, I'm going to show you a list here in a moment, there are several states that have actually included drug testing in their marijuana policy. So nothing in this act in Illinois shall prohibit an employer from enforcing a policy concerning drug testing, zero tolerance, or a drug-free workplace provided the policy is applied in a non-discriminatory manner. Well, that's fair, right? Because, you don't want to discriminate against anybody in the workplace if you can avoid it, although to some extent people sometimes by their behavior bring that on themselves. But in Illinois, it does include that drug testing language. And also, very, very interesting, zero tolerance. Now, this is not because of the benevolence of the legalization folks, the people who want to get marijuana legalized in Illinois, but this is what they could get past the business community, which has a very strong influence on these types of matters in the state of Illinois. This is what they had to agree to in order to get the support they needed to get this law passed in Illinois. You'll see that this is not going to always be the case. The Illinois language goes on to say nothing in this act shall limit an employer from disciplining a registered qualifying patient from violating a workplace policy. Again, your policy is paramount. You must have a marijuana section in your policy, and I'll get into that in a moment. Minnesota. Minnesota passed their law earlier this year. The governor signed it. This is the new frontier for medical marijuana laws, as it relates to the workplace. So you see this language in here. Minnesota's law places restrictions on marijuana use related to all these workplace situations, okay? Operating, navigating, or being in physical control of any motor vehicle, et cetera, et cetera. But they went one step further in Minnesota, which probably did not have the support of the business community there, although Minnesota tends to be very liberal on these types of issues, generally speaking, and certainly here as it relates to marijuana. An employer in Minnesota may not discriminate, and that's a key word, against any person in a hiring, termination, or any term or condition of employment, or penalize that individual if the discrimination is based upon the person being a registered medical marijuana user, and very importantly, number two, and I put it in quotation marks, a patient's positive drug test for cannabis components or metabolites unless the patient used, possessed, or was impaired by medical marijuana, cannabis, on the premises of the place of employment or during the hours of employment. This is important because in Minnesota, you've got to be able to prove not only that the individual had marijuana in their system, which the drug test will do for you, but also that you've got to have some justification that the individual was impaired or under the influence at the time. It goes a step further. And you'll find that Minnesota is really one of the more restrictive states, along with Arizona. I'm going to show you a list here in a moment. There have been some very significant court cases already on medical marijuana, and every single one of them so far have gone in favor of the employer's position. This is one of the most famous ones, Walmart versus Joseph Casillas. Now, Joseph Casillas has brain cancer. He is a registered medical marijuana user in the state of Michigan, and he worked for a company that simply does not condone the use of marijuana for any reason. He tested positive. The company terminated him. He sued to get his job back, and the court ruled in favor of Walmart. And the main reason here, sort of summarizing everything that's on the screen in front of you now, is that the judge said there's nothing in the Michigan law that says anything about the private sector. There are some limited protections in the Michigan law related to the public sector, to the state government, to municipalities. But he said nowhere does the law state that the statute regulates private employment. Therefore, Walmart, being a private employer, had the right to fire Mr. Casillas when he tested positive. That was the first major case. The next one took place in Colorado. Now, this involves Brandon Coates, who worked for Dish Network. He's a paraplegic. He has been using marijuana for medical purposes, and marijuana is legal and was legal at that time for medical purposes in Colorado. He tested positive. Dish Network policy basically said, if you test positive, you're going to be terminated. He was terminated. Mr. Coates sued to get his job back, but the court ruled in favor of Dish Network based on what it claimed was that the medical marijuana use was not a lawful activity covered by the law, even though it was legalized in Colorado. And what was their reasoning for that? Because the federal law considers marijuana illegal. And the judge said because activities conducted in Colorado, including medical marijuana use, are subject to both state and federal law. For an activity to be lawful in Colorado, it must be permitted by and not contrary to both state and federal law. And so based on that, and that's why the Schedule I Controlled Substances Act, part of this argument, is so important. Based on that, the judge ruled in favor of Dish Network. Now, it appeared that that was the final blow to Mr. Coates' legal options, but the Colorado Supreme Court agreed to review the case and to determine whether or not medical marijuana use in Colorado qualified under the state's lawful activities law, which basically protects an individual from quote-unquote discretionary discharge for the lawful use, in this case, of medical marijuana. Now, this is an important case because, and the Supreme Court in Colorado has listened to the arguments. I checked this morning. I didn't see anything in terms of a judgment coming out. It may still be a little while before we see anything like that. But this is important because this will put to the test this, sort of foundational argument that because marijuana is illegal under federal law, then under some circumstances and situations, employers have a leg to stand on, even though it may be legalized by state law in a state where they're doing business. It also has other ramifications. For example, smoking, where employers are prohibiting employees from smoking and they're conducting cotinine testing. And smoking's a lawful activity, but employers have a right to ensure that their employees are healthy, and on that goes. I'm doing a cotinine webinar next month, and so I've been preparing for that. But the lawful activities law that exists in many states will be put to the test in Colorado when it comes to medical marijuana. And so Minnesota's law, which prohibits an employer from terminating based on a medical marijuana user, a registered user, testing positive, is really sort of the new frontier. That's where the pro-marijuana people are going with language for medical marijuana. That's where they're trying to close the loopholes that you saw in the Michigan case and in the Colorado case, so that it's actually written into the law that you can't do anything to discriminate against someone who tests positive. Now, I've said it a couple of times already. We're going to spend a few minutes on this subject right now. This is really very, very important. Your drug testing policy must address marijuana specifically. There was a time when marijuana could sort of be lumped into a list of all the other drugs that you test for, and it didn't have to be singled out. But because marijuana legalization is spreading throughout the country, and because many companies are multi-state employers, and they may be in a state with a medical marijuana law and a bunch of states without medical marijuana laws, it can be quite confusing. And so you've got to address the issue from a policy standpoint. And there are some basics, okay? In your policy, you want to make sure that your prohibited behavior section addresses marijuana specifically. Now, you must look at your state's laws. If you're in one of these states that have passed medical marijuana, then you have to make sure that you're in compliance with that law and that your policy reflects your compliance, your intent to comply with the law. But you want to be clear that individuals may not use marijuana in the workplace, and in states like Illinois, where you have a little bit of wiggle room on the language, that they may not be under the influence of marijuana while at work. If you're in Minnesota, you're going to say the same thing, but you're going to have some tie to reasonable suspicion of impairment in that marijuana section of your policy also. Then when you get to your drug testing section, you want to make sure that you talk about how you're going to drug test, when you're going to test, and for which substances, including marijuana. So you must be very clear, we're testing for marijuana. And then what are the consequences if somebody violates the policy? Specifically, if somebody tests positive a first time, if somebody tests positive a second time after being allowed to go through some type of rehabilitation or treatment program. Your prohibited behavior, your drug testing, and your consequence sections of your policy, those three sections are the most important sections of your policy. Now, the drug testing section can go in a lot of different directions. I'm going to talk about lab-based oral fluid testing in a moment. But you want to be specific about how you're testing for marijuana, when you're testing for it, and who's subject to it. Is it just a pre-employment test, or are employees subject to marijuana testing also? Be clear in the policy, though, that employees cannot possess or use marijuana at work, nor be under its influence, and then you define what under the influence means in your policy. You'll find that of all the states that have drug testing laws, and not every state actually has a statute on drug testing, but very, very few of them actually define what the term under the influence means. Some use the term impaired or impairment, which the courts have ruled long ago a drug testing does not prove impairment. But very few of them actually try to define what under the influence means. So you can define that term for yourself in your policy. And it can be a whole long list of things, right? Exhibiting outward behavior, slurred speech, things of that nature, that may trigger reasonable suspicion because it falls under what you've defined as under the influence. But one of the other components of your definition can be testing positive. A positive drug test can be considered under the influence in your policy, unless you're in one of those rare states that defines that term for you. And if somebody tests positive, detection at any amount, right, just like the Walmart situation in Michigan, that would be considered a violation of the company policy. Keeping in mind that you can take action based on the actions of the individual and not necessarily the result of the drug test. There are times when you can do that regardless of what the test result was. Somebody who's absent 10 days in a row, doesn't really matter if they tested positive or not. If they're absent 10 days in a row without any kind of justification, you can take action based on that. The policy is very important. So I'm going to take you through some sample language. Now, I caution you not to just take this language and use it, because it needs to be modified and revised to be consistent with whatever state laws apply to you. But basically, you want to cover three things. What is the basis of your policy decision? What is the prohibited conduct related to marijuana specifically? And what are the consequences related to marijuana specifically? So the basis of the policy is the company recognizes that some states permit the use of marijuana either for medical or recreational purposes. However, the federal government continues to classify marijuana as a Scheduled I controlled substance, thus making it illegal to use for any purpose under federal law. That's okay to put that in your policy. As long as it stays illegal under federal law, you should take advantage of that, include some language like that in your policy. And that leads into prohibited conduct. So because of this, employees are prohibited from being under the influence of marijuana while at work or on company time, as exhibited by, among other things, a positive drug test result. You've defined under the influence in the definition section of your policy. Now, you're talking about the fact that there's a connection between the two, using marijuana and being under the influence and having a drug test result that proves that the individual has marijuana in their system. Therefore, by company policy, they are considered to be under the influence. Employees are prohibited from bringing marijuana or any marijuana-related paraphernalia to work or using marijuana while at work, including time off, lunch breaks, etc. Okay? And with that in mind, with that in your policy, now you explain what the consequences are. Employees who test positive for marijuana, regardless of the reason for the use or the source from which the employee acquired the drug, will be considered in violation of this policy and subject to possible adverse employment action, as outlined in the consequences section of the policy. Remember, this is sample language for the marijuana section of your policy. You'll find more detail about prohibited conduct in that section of your policy, or on consequences in that section of your policy. But this is where you're addressing marijuana specifically. And the reason I caution you not to just take this language and put it in your policy is because you really must make sure that the language in your policy complies with the with the state laws that apply to you. So what do you do if you're in multiple states that have medical marijuana laws, some being a little bit more protective of employers' rights, like in Illinois, and some being less protective of employers' rights, like Michigan or like Minnesota? Well, you're going to have addendums to your policy to cover this issue on a state-by-state basis, just like you would for any other part of your policy. In some states, you may be prohibited from doing random testing of all employees. In another state, you can do random testing of safety-sensitive workers. And so you're going to address that through addendums to your policy, the same as you would for any other part of your policy. So the policy is really very, very important. This is just for your information, but I talked about how you have to modify the policy depending on the states that you're in and what those state laws say on medical marijuana. This is a list of states that include discrimination language, but actually don't mention drug testing. And just as an example, Connecticut says no employer may refuse to hire a person or may discharge, penalize, or threaten an employee solely on the basis of such person or employee status as a qualified patient or primary caregiver. There's a little bit more protective language in that law, but basically that's what you see in that list of states that I just showed you. These are the states that have medical marijuana laws that talk specifically about drug testing. And so you need to be very careful. It doesn't say you can't do drug testing for marijuana. In fact, no state prohibits testing for marijuana. But you have to be careful that you're in compliance with that state's law. For example, in Arizona, it restricts an employer's ability to discipline a registered user that fails a drug test unless that person was impaired by or using marijuana at the workplace or during work hours. So if they're using it and you can prove that, then you're covered. But otherwise, you have to go back to your definition of under the influence. In Arizona, they've used the word impaired, but you know as an employer that the courts have ruled that a drug test doesn't prove impairment. So you've got to go back to how you define under the influence. All right? Remember, we're getting close to the end here, and we'll get into our Q&A section. If you are mandated by a federal government agency to conduct drug testing, you have to test for marijuana. It's included in every one of those federal mandated panels. Marijuana is the #1 drug in every one of those panels. If you're mandated by a state government agency, you most likely do. It depends on the state, but I don't know of any that exclude marijuana. If you're located in states without legal marijuana laws, just know that the legal marijuana laws in states around you do not apply to you. And if you're located in some states with legal marijuana laws and others without legal marijuana laws, you're not required to impose the legal marijuana standards in those other states in all of the states that you're in that have not legalized marijuana. Now it gets a little confusing. The point here is that you don't have to accommodate the use of marijuana in states where it's not legal, even if in some of the states you're in, it is legal. If you're located in a state with a medical marijuana law, make sure that you're in compliance with that law. You will be held accountable for that. If you're in Washington or Colorado, even though it's been legalized for recreational use, you must still comply with the DOT regulations that require testing for marijuana. And regardless of where your business is located, marijuana is still illegal under federal law. That may not always be the case at the rate we're going. The Marijuana Policy Project has a very aggressive agenda. They are very well funded, and their objective is not to legalize marijuana for medical purposes. Their objective is and always has been to legalize marijuana, period. And this is right on their website. You can find this. But their goal is to put so much pressure on Congress in Washington, D.C. by states passing legal marijuana laws that Congress will have to ultimately legalize marijuana nationwide, and their goal is to have that happen by 2019. In that first paragraph, you see 16 states. That's their goal, 16 states to legalize marijuana. Not for medical purposes, right? They've already exceeded 16 states there. It's to legalize it as they have done in Colorado and Washington. Now, let me just say a couple of words about marijuana and oral fluid testing, just in conclusion. A lot of companies are concerned about how they can test for marijuana going forward. Marijuana is detectable in oral fluid testing within minutes after the person has used the drug. That's the difference between testing with oral fluid and testing with urine. There's about an hour gap before drugs will appear in a drug test with urine. But with oral fluid, it's within minutes typically after the individual has used drugs, especially when it comes to THC. The cutoff levels, though, are very important, and there's a big difference between the cutoff levels used for lab-based oral fluid testing and POCT oral fluid testing. Lab-based oral fluid testing has a longer window of detection than the current POCT devices that are on the market today, especially when it comes to marijuana. But the window of detection for oral fluid testing, period, generally, is shorter than it is with urine and certainly with hair, which has that 90-day window of detection. That becomes actually an advantage in states that have marijuana laws, because now you're just looking at a 24 to 48-hour window of detection. And the cutoff level becomes critical, because if you're using a device with a cutoff level of, say, 40 nanograms per milliliter or 50 nanograms per milliliter, as you can see from this chart, everything to the right of that vertical red dotted line is 50 nanograms or higher. And so the vast majority, 80% of THC positives with oral fluid are below 50 nanograms. And as you can see, the majority of them are below 25 nanograms per milliliter. So if you're going to test with oral fluid, which I think is a good way to go when it comes to THC issues, you've got to make sure that the cutoff level of the product you're using is in an acceptable range. If it's above 40% or 40 nanograms per milliliter, you're not going to get very many positives. You're going to see a tremendous change in the positivity rates of your drug testing program. But if anybody asks, what's the positivity rate, what's the accuracy of lab-based oral fluid and urine, it's very, very similar. As you can see at the top line there, 4.1 to 4.4%, but the THC line, virtually the same with lab-based, which is the middle column, and urine testing, which is the column on the right. So that's a vote in favor of oral fluid testing, and it kind of points us back to one of our co-sponsors today, OraSure Technology. And with that, I'm going to turn the microphone back over to Jennifer.
Bill, thank you so much. We have some questions for you that have come in from our listeners. The first one's going to be from John. John writes, are there any laws that specify an employer's willingness to accommodate recreational or medical marijuana users?
Yeah, that's a good question. Only about half of the states that have legalized marijuana in one way or the other have language that is specific to the workplace. Now, none of those laws require an employer to not test for marijuana, for example. But they do often require the employer to be very careful in how they treat an individual who's a registered user. And I can't really be more specific because it's really something you have to deal with and answer on a state-by-state basis. But if you're in a state that has a medical marijuana law, or if you're in a number of states that have medical marijuana laws, I would strongly advise you and encourage you to read those laws and find out what specifically they say about the workplace, because every single state with a medical marijuana law, for example, is different from all the other states.
All right, let's go on to our next question. It's from Jeff, and Jeff asks, so how does someone take disciplinary action against an employee who violates the DOT zero tolerance policy for Minnesota workers who are protected under the state law?
Well, keep in mind, Jeff, that the DOT regulations do not require or mandate or even encourage an employer under the DOT regulations to terminate the employment of somebody who tests positive. So I always tell people when we write policies for them that where the federal law ends, the state law picks up. So you must test for marijuana. An individual who tests positive for marijuana under a DOT testing program must go through the substance abuse professional, the SAP evaluation process, et cetera, especially if they're not going to be terminated. But in Minnesota, you would be prohibited from terminating that individual unless you could show, as you know, there were those conditions that were in the Minnesota law, or you would resort back to the Minnesota drug testing law, which also does not allow an individual to be terminated for a first-time positive result unless you could show that the individual refused to participate in treatment and some other conditions that apply. It's a great question. It's not only applicable and very important in Minnesota, but in all the other states with medical marijuana laws. And you have to look at those laws to make sure that where the DOT regulations end, you're still in compliance with the state law that applies to you.
All right, thanks, Bill. Let's go on to Nick. And Nick writes, the New Hampshire law makes me wonder if there have been any efforts to develop a method to test for whether workers are under the influence or impaired by marijuana that's similar to the blood alcohol test.
Yeah, that's a good question. And also there's some, I would say not discrepancy, but there's some disagreement there on whether or not a certain cutoff level proves anything in terms of impairment. So you have the 0.08 DUI level for roadside testing for alcohol. And at least in the two states that have passed marijuana for recreational use, Colorado and Washington, one thing that they've agreed on, even though their laws are different from one another, the one thing that they agreed on is that a 5% nanogram per milliliter cutoff level is the accepted level at which somebody would be at least in violation of the law when it comes to DUI. So in other words, somebody who tests positive 5 nanograms per milliliter, I should have said, in a roadside drug test would be considered, quote unquote, under the influence or in violation of the state's DUI law in Colorado and Washington. But aside from that, there's no sort of federal level as there is with alcohol testing. But as more and more states pass marijuana legalization laws, we may see that actually happen.
We have a really interesting question, Bill. This comes from Karen, and she writes, I'm in Washington State, and I have already had one person come in from being exposed to brownies with THC in them. Do most states include eating THC?
Great question, and that falls into the category of unintended consequences. And that's one of the things that they're dealing with both in Colorado and in Washington, where marijuana can be consumed many different ways, including through edibles. And of course, we've seen the horrifying headlines of young people who have actually consumed marijuana-laced edibles in Colorado and have become ill. Some have even lost their lives, unfortunately. But so far, none of the states that have addressed this issue from a legalization standpoint, and really we're talking Colorado, Washington, Oregon almost, and then the states that are voting on it next week, Arizona, Alaska, Oregon, California, and the District of Columbia, they've not really included much in the way of other types of marijuana consumables like edible products. I think you're going to see that come to pass, but right now there's really no way to regulate it. I mean, think about it for a moment. There are really no FDA standards that are applied to marijuana, let alone edible products that contain marijuana in them. So really, if you think about it, it's a very dangerous situation that we're in right now, because some products may be more potent and therefore more dangerous depending on the user than another product. And so at some point, as this continues to catch on, we're probably going to see that happen as well, where there'll be standards established for edible products.
Okay, Bill, I'm looking at the clock. We've got about 3 minutes left, so I figure we can get one more question in here. It comes from Sandy, and she writes, should companies that are not DOT not test unless they are in a safety-sensitive job?
Well, my personal opinion is no. You should still test regardless. And here's one very important reason among many why I come to that conclusion, which is that as an employer, you're going to be held responsible from a legal standpoint for the behavior of your employees. And so even if they're not in a safety-sensitive position, but they're in some way representing the company, and they're doing so under the influence of marijuana, even if it's legal in that state, you're responsible for their behavior when they're on company time and conducting company business. And if, heaven forbid, something terrible should happen, an accident occurs, an injury is the result, even the loss of life, as an employer, you want to at least be able to go back and say, we have a policy in place, we do conduct drug testing, we do test for marijuana, these are the consequences, and we're making a good faith, a best practices effort. There may still be some liability that you're exposed to in that situation, but at least you can show that as an employer, you're a good citizen of the state, you're doing everything you can to combat the problem, and here's my policy to show that we're doing that. So I would continue to test for marijuana, even in states where it's been legalized, even if we're not talking about safety-sensitive workers.
All right, Bill, thank you so much. And there's so many more good questions. I'm sorry we weren't able to get to all of them, but we're up against the clock, and that's all the time we're going to have for today. Now, if you're interested in Screening News, visit our blog and our Screening News Network, and you'll find weekly videos there to keep you up to date on industry news. We are also offering a white paper right now called Legalized Impairment, What Employers Can Do About It. Please feel free to download it from the URL that you see right there on your screen. On behalf of OraSure Technologies and EBI, we hope you found today's presentation informative and helpful. This presentation was recorded, and you will receive instructions informing you how to access the recording very soon. This concludes today's webinar. Thanks for joining us.